Great. Okay, let's get started. So good afternoon, everyone. I'm Julia Porter. I'm a partner at Data Protection Network Associates. I'd like to welcome you to this webinar from the Data Protection Network, sponsored by our friends at OneTrust, and it's entitled Post-Brexit and Schrems, What Next for International Data Transfers? I think we're going to have a very lively debate about that. So thanks very much for joining us. We think it's going to be an interesting and insightful hour. You may ask questions to the panel as we go using the chat button on your screen. A number of you have submitted questions in advance already, and we've woven them into our list of questions. We are recording this session, so it will be available for you to view again if you wish, and you should receive a link to the recording by email about this time tomorrow. If you don't receive that link, double check your junk folders because sometimes it falls in there. So your panel are on the screen now. We will be introducing you to everyone in a minute. But first of all, I just wanted to tell you a little bit about Data Protection Network for those who have not attended one of our events before. So the Data Protection Network is a thought leadership network and data protection consultancy helping clients both large and small with data and privacy matters. We publish a wide range of useful articles, guides and opinion pieces alongside our upcoming events on our website, dpnetwork.org.uk. We also provide training workshops for your teams who handle personal data. These are always practical and engaging sessions, and we use relevant examples wherever we can to bring it to life, which really improves the learning experience. And of course, we also run a range of events like this one today. And coming up very soon will be another of our webinars called the Cookie Boot Camp on the 11th of May, where we want to cover everything you need to know about cookies. Please see our events page for details. So I'd like to thank our sponsor today, OneTrust. And with that, I'm going to pass you over to Robert Bond, our chair for the day, who will introduce you to the panel.
Thank you. And apologies that you don't have me live, but my signal has not been great. So I'm afraid I'm here in person, but not in live face. But I'm here just to thank OneTrust as the sponsor for today on behalf of the panel. As you know, they're the #1 fastest growing, most widely used platform to help organizations to be more trusted, to be compliant, to govern their data better. And we're delighted to have a representative from OneTrust with us today. And with that, if we could move to the next slide. The panel today is me moderating. I'm a senior counsel in the notary public with Bristows law firm in London. I chair the governance board of the Data Protection Network, and I've been doing all things data protection for about 35 years. With that, I'm going to ask Julia to say a few words about herself, and then we'll move on. Julia.
Hi, thanks, Robert. So I'm a partner with DPN Associates. I have wide privacy experience with a particular interest in ad tech and cookies. I was previously the chair of the DMA, the Data and Marketing Association, marketing director at Guardian News and Media, and CMO at ITV. So I'm very passionate about good data governance. I led the development of the DMA Code of Practice and the Guardian's innovative Why Your Data Matters campaign. So over to you, Yasmeen.
So hi, I'm the Group Data Protection Officer for Informa, and we're a global B2B organization. We run a host of media sites, publishing, academic and otherwise, and also events, hybrid and in-person eventually when the world turns back to normal. So I've been leading the privacy team at Informa for just over 3 years now, but I've been in data protection for going on 10 years. And previous to Informa, I helped set up the BMW privacy function as well. So I've got a varied background. I've also done enterprise risk management, IT security, as well as IT management. So I bring a lot of practical experience, I think, into my role.
Thank you, Yasmeen. And then finally from OneTrust, Joseph.
Oh, hi. Yes, Joseph Byrne. I'm a privacy solution engineer at OneTrust, and my main role is to show people how you can solve privacy challenges using OneTrust. But outside of that, I also speak at a lot of events throughout the year. Perhaps the most exciting part of the job are taking part in panels like today. Past 2 years, particularly at OneTrust, I've been living privacy. So fair amount of knowledge on that, and delighted to be taking part today.
Thank you. And we've got a poll, so I'm going to hand back to you, Julia.
Thanks, Robert. So we've got a couple of polls today. We thought our first one, and we'd love you to answer the question. So the first one is, how concerned are you about the compliance of your international data transfers? Is it not at all, a little concerned, or very concerned? You want to press your buttons now. Still moving around a bit. So it doesn't look like anyone is not concerned. Great. Oh, hang on. Yeah, someone is not concerned. Brilliant. Thank you, everyone. So it looks like 64% of you are a little concerned, 31% very concerned, and 4% of you are relaxed and not at all concerned. So I'm just going to give you a quick run through of what's been going on in the last few months, and then we'll start out with our debate. So Simon, can we get the charts back up again, please? Fantastic. Thank you very much. So first of all, just a bit of context, what's been happening in the last year. So as most of you will know, the Court of Justice of the European Union declared the EU-US Privacy Shield invalid on account of the invasive US surveillance programs in place, which meant that transfer of personal data on the basis of Privacy Shield decisions was declared illegal. And at the same time, the court stipulated stricter requirements for the transfer of personal data based on standard contractual clauses. So there was a bit of uncertainty about what you could and could not do with standard contractual clauses. It also said that controllers and processors must ensure the data subject is granted a level of protection equivalent to the guarantee by the GDPR and EU Charter of Fundamental Rights. That's a bit of a mouthful, but fundamentally this meant that if you weren't able to do that, the transfer of personal data should cease. Now this, I have to say, came as a bit of a shock to many organisations. And in particular, I think the area of risk is any organisations who are using software as a service, technology solutions, and particularly those that are based in the US. And many of these suppliers are US based. And I know Max Schrems said, well, it's fine, we can just solve this problem by buying solutions from the EU. I think it's fair to say that didn't really cut much ice, not least because there aren't as many solutions in the EU. So just as a revision note, what are standard contractual clauses? The ICO gave a nice snappy little response here. They're a standard set of contractual terms and conditions which the sender and the receiver of the personal data both sign up to. They include contractual obligations which help to protect personal data when it leaves the EEA and the protection of the GDPR. So these need to be used if you're exporting data to a third country, such as the US. You don't need to use them if a country has an adequacy agreement with the EU. So certainly from the UK's perspective, on the basis that we're assuming we will gain an adequacy agreement, then the free flow of data between us and Europe should continue. Fingers crossed anyway. So what to do? So the initial advice was that anyone who's relying on Privacy Shield should be prepared to sign SCCs. That all sounds pretty straightforward. However, signing the SCCs isn't entirely plain sailing. The court didn't automatically rule that they were invalid, but ruled their use needed to be assessed on a case-by-case basis, and it might be necessary to put in place supplementary measures to protect the data subject. So that's an additional level of complexity without specifying exactly what you needed to do, which obviously creates a huge overhead within the privacy teams as to work out what they should be doing. So what are supplementary measures? That was the other question. There's generally a fear that the US federal government has significant surveillance powers. And the truth of the matter is we've got quite significant surveillance powers here as well. But I guess the questions to ask yourselves is, can you encrypt your data further? Can data be stored in EU data centers and kept separate from the US data centers? And are those measures sufficient, or should they be thinking about other solutions? You also see providers now who are talking about GDPR pseudonymization of data. So there's all sorts of technical solutions out there as well to help people protect their data. Interestingly, there's a useful case study which provides some assurance around ring fencing data. So the CNIL had a complaint raised with them in France. There was a COVID vaccination site based in France, which was hosted by the US company Amazon Web Services in Luxembourg. So it's a US business. However, Amazon Web Services were deemed to have introduced sufficient supplementary measures. So they had effectively ring-fenced their data center in Luxembourg so that there was no connection between that and their data centers in the US. So that data silo, in CNIL's opinion, was sufficient supplementary measures to protect personal data. Meanwhile, soon after the court case, the EU published their draft version of the updated SCCs. And these have actually been in the pipeline for some while because they were published quite some time ago. This was a happy coincidence, although I suspect it was rushed out as soon as the CJ-EU judgment was made. So the old SCCs were out of date. As I said, they were inflexible. There was no provision for processors. So everyone was actually pretty happy when the draft came along. And the main differences are that now the SCCs are modular, which means you can accommodate a lot of different scenarios where you can pick the pieces that relate to your situation. In the previous iteration, you had to use the whole document and not make any changes. They cover 4 different transfer scenarios. So controller to controller, controller to processor, processor to controller, and processor to processor. Also, more than 2 parties can accede to the SCC, so it reduces the workload in terms of putting them in place. And once they are adopted and approved, there's a 12-month phasing program to actually introduce them. So there's a little bit of leeway, although I think for some complex organizations, that will still seem like quite a big ask. And I think Yasmeen probably will have have something to say about that. Yeah. And then finally, Brexit. So obviously, any country with an adequacy agreement does not need to worry about SCCs between themselves and the EU. Let's all hope that our draft adequacy agreement for the UK actually translates into an agreement. So we wouldn't need to worry about data transfers between us and Europe. We do, though, need to worry about data transfers between us and the US and any other third country. The other thing to bear in mind is that the EDPB will be watching the UK very carefully to make sure that we do not diverge from EU data protection regulations. They actually mentioned it last week and said they'll be watching us. And given that our government seem to be indicating they would like to diverge, it will be interesting to see whether we get ourselves into hot water over the SCCs. So that's the scene setting. This is basically where we're at now. And so given that there is quite a lot of uncertainty and we are in a period of limbo, today's discussion is really to figure out what to do next. So I would like to do our second poll now, please, if you don't mind. And the second poll is, do you know where all your data processes are based? And it's really all straightforward. Yes, no, not sure. Off you go now. Great. So that's an interesting split. 50% do, 25% don't, and 25% aren't sure. So I think we can see just from that poll that there's quite a lot of uncertainty actually about what are we going to do next. So I'm now going to hand back to Robert, who is now going to manage our Q&A session.
Thank you, Julia, for that overview. That's very helpful. I can see that there are questions already coming in, and I will try and make sure we get to those. But before we get into the formal Q&A, I'm going to ask Yasmeen if she can provide an overview of your project, Yasmeen, at Informa for us.
Yeah, absolutely. I sort of feel like I've been talking about data transfers for several years right now. I think it went right back to when we were exiting Brexit. It already hit our radar, if you like. So coming into 2020, we already knew that was something that we had to prepare for. But then we knew that Schrems was coming down the line as well. So as soon as that judgment hit in July of last year, we went straight into a brainstorming session with some of our key lawyers in our privacy team to say, what did we think? What were the repercussions on us? What could be the practical implications? And out of that brainstorming session, we actually came up with a 9-point list plan already of things we would probably need to do. But I think the view we took was there was still a lot of uncertainty about exactly what the Schrems judgment meant, what additional measures would need to happen and so forth. So we did take a bit of a wait and see approach. There's no doubt about that. But in the meantime, we are actually a client of OneTrust, and we have been for about 2 years. So, the first thing we actually started to do in the background is start to look at our data inventory. What did we have in terms of knowing our vendors and where they were and so forth, and really start to do the analytics to start to put a risk-based approach into place. So last year, I think, was very much start in the background quietly and think about what we need to do. And then this year, we're really starting to take action because, I think we need to move forward, change our processes, change how we analyze vendors, make sure we have all our due diligence in place. So that's kind of been our journey for the last 12 months, I'd say.
Thank you. Okay. I'm going to delve into the questions that we've got. And I'll come first to you, Julia. From your experience, what do you see companies doing right now when we're waiting for the new SCCs? We haven't quite yet got an adequacy decision. Are people just sitting on their hands, or are people, spending a lot of time on this? What are you seeing?
I'm probably not seeing either of those two things. I think they are spending some time thinking about it. There's clearly quite a lot of work you should be doing anyway in terms of managing your contractual arrangements and your partnerships, which should go ahead irrespective of whether SCCs are in place or not. So, auditing the activities of your suppliers, understanding and making sure you've got the correct due diligence in place, making sure that you have your ROPA up to date, but also triaging the relationships with your third parties, because there's absolutely no way you're going to be able to have a thorough investigation with every single contract that's in place. And any solutions where it's software as a service, where it's places like the US, but also other territories such as Southeast Asia or South America should also be considered. It's just that the Schrems case has highlighted the importance of international data transfers, but in actual fact, you should be thinking about it in the context of every single contract you have around the world, and particularly for international businesses, they've really got to think very hard about how they manage their data internally as well as with their third parties.
Okay, and just coming back to you, Yasmeen, looking at this from Informa, are you finding that you've got buy-in globally as to how you're addressing this, or is there still diverging views from the US side?
Internally?
Yes.
I think it's been a case of managing stakeholders very carefully. And so, we've been in touch with our key legal teams right from the get-go. So as soon as these changes, as soon as the Schrems case was announced and the judgment came through, immediately contacted both our US legal team and, as Julia pointed out rightly, our APAC-based legal team to say we're going to start to re-examine the legal framework around data transfers, to flag it up and say we were going to do work in this area. So I think it's been a case of always just working with them so they know that changes are coming down the line, and also using their input as well and their expertise and local knowledge on what's happening as well. So we've very much worked with all our internal stakeholders and got them working with us. And
I'm actually going to, there's a question come in as we've been talking, and I'm going to ask you, Joe, to comment on this. the question is around how do you manage remote access? In other words, we often look at this from Europe and say you can't push the data to somewhere else, but in a multinational, how do you ensure that it's not being pulled?
That's a good question. I think it comes down to having an adequate record of processing activities so that you've got visibility of how the data is moving and what those transfers or trajectories, I call them, are. And you also need to drill down further, not only to your processes, but perhaps their sub-processes, and get visibility of that as well. So if you've got a robust ROPA, there shouldn't be any surprises. If someone is pulling that data and it's not something that you've got written in any of your contracts, then that's a breach of contract on their side. They shouldn't be doing that.
Yeah, and it's interesting. You've all talked about the record of processing activities. Just a comment from me as a lawyer. I've in every instance, to be fair, when I've been advising multinationals, in the middle of this exercise, it's become quite apparent that it is not a robust ROPA, that in fact, the audit has teased out a whole number of instances where data is being transferred. And I think we're still living in a click-through world where a part of the business will merrily find some hosted solution and go with it, and it doesn't always get run past compliance. I don't know whether you find that, Yasmeen.
I hate to say it, but it is true. I mean, I'd like to think that we do a lot of education across our organization. And again, because we're an international organization, we don't just look at data transfers from Europe outwards, actually. So the way we've set up our vendor process and our records of processing and so forth, they're really examining the point-to-point transfer. So we also do the same level of due diligence and onboarding for example, if we are onboarding a system in Japan. And so we'd be asking the same sort of sets of questions about where is that data hosted, where is it going to, how will it be secured, do you use any sub-processors? So to be fair, the way our privacy program framework works, we try to export that sort of international standard across the organization. So while I'd love to think everything goes through it, I know in reality that there probably are gaps, but I think we've seen, a sea change because people are aware of SHREMs. It's quite surprising. You do get questions coming in, about these things. So they do want to do the right thing. We've just got to make it really easy for them. And that's one of the key things that we've done by introducing OneTrust, by the self-assessments and things, and they can do things themselves. We've just really tried to make it easy for them to sort of engage with the compliance team.
So just following on from that, one of the other questions that we've had in, and Joe, I'll come to you on this, is what could you or what should businesses be doing to create templates, to create adequacy assessments, to create mechanisms to review third-party contracts? Can you give us some thoughts about what you're doing? What you have?
Well, the shorter answer is that within our platform, all of those things exist already, and they've been built by a data guidance team of lawyers and analysts. So as a client, all of that's ready to go. If you didn't want to go down that route, then it would be a case of doing your own legal research and perhaps leveraging an existing standard or guidance notes from the ICO and putting those things together from there. But I would sort of try and impress upon people that it's not really something you should be Googling. You should go to maybe the ICO or another institution and leverage their information rather than just research generally.
Okay. There's several questions coming in about, we're the small company. Are we really going to tell the big company how they're going to protect us? Linked to that is some comments as well about, well, what about the exemptions or the other lawful grounds for processing? We're focusing on SCC and Privacy Shield, but to what extent, for example, Julia, do you see companies using things like contractual necessity or, law enforcement or, legal claims as justifying a transfer internationally?
Well, I suspect small companies won't be worrying too much about those things. What I've seen with small businesses in particular, or in fact, even sort of medium-sized businesses, is that they have to make a judgment about whether the partner they're working with, and I noticed one person commented about Dropbox and MailChimp, is to do an exercise with those partners to establish whether they've put in place the necessary guidelines and safeguards in their own organization to protect data, particularly around security and cybersecurity, but also even just being able to establish whether they seem to understand what the EU GDPR is quite an important question. I think the biggest risk is if you're dealing with small tech startups based in maybe California or somewhere like that, then they often don't consider the EU regulations to be something that they should be concerned about. So I think there's almost a triaging of, if you're talking to MailChimp, there's a good chance they've done all of the kind of necessary work to protect the data. And so your level of risk, if all you're worrying about is names and some email addresses, is probably relatively low risk. If though you're talking to a small business and you're sharing a lot more data with them and you're not entirely sure about how robust their security is, then that's clearly a higher risk. So I think you need to kind of assess, and you're right in that MailChimp are not going to change their terms and conditions for anybody. And so therefore you decide you're going to take that small risk, or you're going to go and find another supplier that's based in the EU. And this is precisely the Max Schrems point, is like, find someone in the EU. My suspicion is that over time, all of these big suppliers will have data centers in Europe and ring fence their data anyway, like AWS have done. And certainly people like Salesforce have done that as well. So, they have completely ring fenced data centers, which gives you a certain amount of assurance about the ability to have data moved to a third country.
Thank you. Just a comment. There have been a number of instances where you physically ring fence the data on a server in Europe, and then along comes, the US with their interception rules, etc., who go, well, it's still a subsidiary of an American company, so therefore we're going to enforce our warrant against anything that's an affiliate anywhere. So that's still quite a concern. Of course, just from the chair here, I would say sitting on your hands and doing nothing is simply not an option. To be on the road, to be on the process is by far the best thing, even if you're not able to get all of the assurances you want. I think if you could show a regulator that you were moving in the right direction, I think that would be extremely useful. Yasmeen, how are you managing the risk with sub-processors of your processes? How far are you drilling down?
So to be fair, historically, we always have asked about sub-processors as well. So in our due diligence setup, when we do our privacy risk assessments, we don't just ask where is our processor operating from and their offices, but we do actually ask who are your sub-processors and which locations as well. So we've had a lot of that information, thankfully, gathered. And that's come in quite handy when we've done our risk analysis as well. Because then when we ran analytics back last September, October through, out of OneTrust, we were able to pull that information forward and out of the system and be able to sort of risk rank a lot of our vendors in sort of high risk and low risk. So it gave us somewhere to start, basically. So I think it is an important thing to establish, though. You can't just stop at your main processor. You've got to understand the onward transfer.
What do you do when you're doing your due diligence and your third party still has a website that says we are Privacy Shield? Do you remind them of the court decision? What do you do? We're all laughing, but I'm just intrigued. I don't know any of them.
I have to admit, it does still happen. So often with critical platforms, at least, that I get involved in, we'll go through a 3-bid process, for example. So I might early on sort of have a look at their websites and look for those sorts of certifications. And if I see things like Privacy Shield certified still on the website, I may just flag that back into the team to say, well, can we go back and see what they're actually doing about this, because they became invalid last year. On one hand, though, if they've gone through the effort of putting Privacy Shield in place in the first place, it does actually mean that they have made a commitment to good data protection. So I don't think you can discount it entirely, but as a mechanism, you can't rely on it. That's my view, at least. So yeah, we enter into a discussion.
So interestingly, I have been in that position with one of my clients where they had Privacy Shield still up, and they had fairly recently signed a contract with them, so had made a commitment to set up this CRM solution. And I did speak to them and say, you need to update your privacy. And they did update it. But actually what was most interesting and slightly alarming is that they said to me, and they're quite a big supplier, and they said, you're the first person to have mentioned it to us. So you do kind of wonder how many other people have the time to actually look and see what's going on. I was looking because I was providing some advice to them, but I suspect with everything else that's going on in business, you often don't necessarily get around to looking.
Yeah. Joe, any comments?
Well, to that point, I think it's a bit like health and safety. If you're in that industry, certain things you can't ignore and they jump straight out at you. And I noticed that someone's relying on Privacy Shield on a public-facing website would scream out at a privacy professional, but perhaps someone who's not as heavily involved wouldn't see that. I suppose it is good that they've taken the time to put that in place, and it was perhaps unrealistic that there would be a step change as soon as it was made invalid, because it was pretty much an overnight decision when it happened. So I would perhaps speak to whoever's responsible for privacy there. They might not be aware of that still being presented on their website, and have that conversation as to what they're doing about it. Okay.
It's interesting. I was on another organization's conference last Friday. My co-presenter was a US privacy compliance attorney, and he said, well, it's interesting from a US perspective, if you are Privacy Shield certified, the Federal Trade Commission requires you to continue to comply with Privacy Shield. So when you look at it from a US perspective, they're not necessarily wrong. They're still holding themselves out as Privacy Shield compliant. And I mean, I suspect from a US perspective, they're thinking, well, it won't be long before Europe gets its act together and we'll have Privacy Shield too. So yeah, it's one of the attendees has just said, I work for a US-owned company, and the whole thing has caught them, by surprise. They just don't understand the EU perspective. So it's, we sometimes have to see the other side as well. We've just talked a lot about the US. Just changing tack, one of the other questions is, to what extent do you red flag, orange, green, etc., different jurisdictions? Joe, how do you manage that within the platform?
Well, we can certainly flag where all of the data is being stored, and we can produce very quick reports to highlight those. And if then one of those is a concern, the organization can look and investigate. And what you'll find, like we were discussing earlier, is the majority of big suppliers are SaaS based. So it may just be a call to their rep to say, can you move this data to Europe to ease the challenge or ease the problem there. So I suppose firstly is getting visibility, which we can do quite easily with our records of processing activities, and then choosing a rational action, whether the data should be there or not, and if it's not, figure out where it should be.
Okay. Do you think we're going to get, Julia, awkward questions from Europe about UK and its own jurisdictional challenges, four-letter agencies, etc., or do you think we're just going to be seen as nice people soon?
I think we'll get challenges, actually, because I think we're being slightly schizophrenic at the moment about what we say we'll do and what we have to do versus what we say we'll do. So I think government talks a lot about divergence and wanting to have a more flexible, more entrepreneurial way of doing things, and are slightly disparaging about EU law, yet not necessarily understanding what we need to do in order to maintain adequacy. So achieving adequacy is one thing, but maintaining it is another matter altogether. And I think the EU will slap our wrists fairly rapidly, actually, if we start to diverge too much.
Yeah. Yasmeen, any thoughts?
I agree. I mean, to me, it feels like there is a lot of rhetoric right now without substance. So I'm not going to put too much, weight behind that for now. But it does kind of worry me. As a global data protection officer, we're an international organization, so we really do our best to put in, large-scale international standards in place in our offices and through our data transfers. So for the UK to now start to diverge substantially or significantly from Europe, it will mean quite a difference for us operationally. So I'd like to think that we would stay aligned to Europe. But yeah, I think we just have to wait and see.
And again, just comments from me. If you look at the new ASEAN data management framework and their new standard contractual clauses, hey presto, they look like ours.
Yeah.
Abu Dhabi's looks just like ours. It's not like we're not all heading in the same direction. And I just don't think we can afford to diverge from GDPR because we'll be out of line with what Singapore wants or Malaysia wants or Japan wants, etc. The interesting thing is the sort of odd one out, which is the US, which is sort of still doing its own thing. But again, it won't be long before we'll have a federal law, I suspect, and they'll be then picking up on the same things. So one of the questions we've got is it really worth, is it too much like hard work? Do you think we should just say, oh, nobody's going to come at us. We're not business to consumer. We're just a global manufacturing company. This doesn't make profit. It'll get sorted. Because that's the sort of comments I'm hearing. I don't know whether you're hearing that, Joe.
To be completely honest, yes. And some businesses have made the decision just to sit it out and wait, and they weighed up the risk sort of to their team and their business, and they thought that was their strategy, was to do nothing. I'm not saying that's good or bad, but it's a decision, which is something. So I certainly have seen and heard that in the industry. I'm not going to recommend or not recommend, but I think what's important to consider is the sort of risk it's presenting to your business, and then determine whether you're happy to tolerate that risk. And if you are, then that's got to be a consideration.
Yeah, I mean, are you seeing that, Julia?
Yeah, I mean, I think it comes down to what data are you processing, and how risky is that data, and how wide is it? And I think they will then risk assess what to do. I think the other thing is that for most organizations, even medium-sized organizations, there are so many contracts with so many partners, you can't possibly treat them all the same anyway. So my expectation is people might pick off a few that feel riskier, where obviously data is moving into other territories, particularly with technology solutions. But I think quite a lot of people are wanting to wait and see. And to be perfectly honest, because there's so many other things going on, particularly through the pandemic, I think businesses have been working hard to survive as much as anything else. So some of these slightly arcane discussions about standard contractual clauses don't feel terribly pressing right now.
Yeah, and again, what I've seen since the Schrems decision is a lot of organisations that have started the process, done the things that Joe was talking about in terms of let's have a look at our record of processing activities, and then suddenly realised that there are a lot of blanks, and then started to categorize the bigger contracts, the more risky contracts, etc., and prioritize on that basis. And then sort of some of the more risky contracts, then what's happened is the requirements for additional measures. And one of the questions we've had is, what would you expect to be getting in terms of additional measures over and above what the SCCs say? Do you ask for more indemnities? What do you ask for? What would you be asking for, Yasmeen?
So we're still working through that one a little bit with some of our vendors, but we're probably looking more at security controls. So we're really examining how does that data transfer happen? Is it encrypted end to end? Is it encrypted at the supplier? So we're really looking at technical and security controls, if we can be provided with additional measures in that sense. But it is a challenging one, I think.
Julia?
Well, I think the problem with indemnities and liabilities, you then spend a very, very long time arguing about quantities and amounts and trying to quantify what they are. I'd agree with Yasmeen, actually. I think, introducing security controls is something that makes obvious sense, and I suspect it's your first port of call. If we're talking about data centers, then the second obvious port of call is to see whether you can have your data center sitting in Europe, which reduces the risk significantly. And then I guess another point is to really think quite hard about whether you can minimize the amount of data that you actually include in that solution, in that processing. And actually, that's just part of GDPR anyway, isn't it? It's like, how much data do you actually need to process? So it comes back to the kind of basics. Is if you do the basics right, then you're reducing your risk anyway.
And do you think that going through the DPIA process is something that should be, an automatic for any data transfer situation? What do you think?
Yeah,
Julia?
Yes, I do. Well, in fact, I think any technology solution or any kind of large contract which requires potentially new ways of processing data should always have a DPIA in anyway. My experience of DPIAs is if you ask someone to do a DPIA, then there's this sort of voyage of discovery when the organization collectively discovers what people are actually planning to do with the data, because I don't think it's always necessarily shared and understood. So I'm actually a bit of a fan of DPIAs.
Okay. Joe?
Yeah, and they can be very efficient if you've got the right team and the right system for doing them. And as you say, insightful, and it doesn't have to be a single round. You can send it for approval and send it back again if there's a few extra bits that need adding or changing, or if something isn't clear. And you can also build risk into that. So if it's answered in a certain manner, set up the next steps and inform the next people automatically. So it can be a very efficient process and doesn't have to be lengthy and time consuming.
Okay. Another question, and I'm going to come to you, Yasmeen. We've all made comments that it's not always possible to silo in the EU. Have you found any other technology solutions that are not US owned, US headquartered, or have you not even bothered to look? That's not a criticism, that's a question.
I think being a global organization, we actually do use vendors that are some are based in Europe, some are based in the US, and some are based in APAC, particularly the ones that are servicing and providing services to our APAC-based companies. So the idea of hiving everything into Europe is just not something that's would be feasible in our organization. So we just have to get comfortable with the fact that there will be data sitting with vendors in platforms around the world. I think that's where our compliance program kicks in, because we're trying to make sure that we understand all those vendors, how they manage that data, what data it is, what the nature and sensitivity of the data is, and all of these sorts of things. So so the idea of just hiving it into one big silo in Europe is just not feasible for us. So we have to be thinking about these other measures instead.
Yeah. Okay. And Julia, any comments?
I agree. I mean, I think there are starting to be. My impression is there are more suppliers now available in Europe than there are before. Having said that, I've just done a whole procurement program with one hospitality company, and we have signed up with a Czech company, an Australian company, a US company, and a UK-based company, all technology solutions. So you're starting to see greater variety. I think where we did get a bit concerned is that we were talking to a business who was American but were owned by a Chinese business, and I think we did reject that straight out of hand on that basis. That just felt a little bit too risky, wrongly or rightly. I may well have been wrong, but we just said, no, we're not going to talk to you. But I agree with Yasmeen, is that, you know, you have to take an international point of view on this. And I think you have to also look at the best solution for your business problems. I don't think the choice of jurisdiction is going to be something that your business team or commercial team are going to really be terribly concerned about.
And again, just a comment from me on that. I think that if you're doing the DPIA approach, which we've talked about, I don't think from a compliance point of view, you should be afraid of concluding that the business is best served by not necessarily outsourcing this particular project. That, you know, the checks and balances we would have to put in place are going to eat into any of the savings we're going to make, and actually the best decision is not to do it at all. But on occasions, I think that, you know, we're driven by cost savings or convenience without doing analysis, and that's of course where the, you know, rightly the CJEU was saying you need to do an assessment. One of the other questions here, and I know we're all sitting in the UK, but I'm sure that we know enough clients that are US headquartered or non-EEA. What would you advise a non-EU UK processor to be doing in order to sell its solution to somebody over here? Are you getting those sorts of questions, Joe, from your US clients about how to proactively sell their compliance to get business or keep business?
Not that often, to be honest, at the moment, although it is something that does come up occasionally. But essentially, we try and impress upon them that if you want to do business in Europe, you need to be GDPR compliant and be able to demonstrate that, regardless of where you're based or who your intended market is. And it makes sound business sense, because if you're not doing that, you're closing off big swathes of potential customers and clients. So that's what we really try and impress upon them, that it's best to try and be compliant with the markets you intend to work in.
Yeah, and Julia, any thoughts?
I think in reality, most US businesses are aware of, most grown-up US businesses are aware of what they need to do in Europe in order to sell effectively, because they will get that pushback. The other point, though, is that you may well have a business selling to the commercial part of your organization, and it's quite late in the day with a contract when the data protection team, privacy team actually get involved, and they have that, oh my God, you haven't done that, have you, conversation. So it kind of depends where the conversation starts. But my perception is that they make some effort to comply with GDPR. The results can sometimes be a bit patchy, but also my impression is, as time goes by, the US government is going to take a slightly more GDPR friendly approach with the federal law, and you're seeing more state laws being passed which are more GDPR friendly as well. So I think the direction of travel is a good one from our point of view.
Okay. We had another question in about when do we think we are going to see these new standard contractual clauses being finalized. I thought, says the individual, these were supposed to have been sorted ages ago. Joe, what do you think?
Shortly is what I would hope, but I can't say for sure. But I would hope, in the next maybe month or maybe 2 months or so. But we have been waiting a while, and there doesn't seem to be a huge sense of urgency around them, from what I've noticed.
And suppose, Yasmeen, that they are finalised in, I don't know, let's say June. Is your plan to immediately switch over to them?
For all new contracts, at least, yes. So, I think there's a forward position which we're putting into place now. So we're building, we are reevaluating our vendor onboarding process to make it more robust, to do a more thorough transfer risk analysis. So we're already putting those measures into place. So hopefully, if the new SCCs come in place, we'd immediately start using them for all new contracts or all renewals. In terms of historical contracts, I think that's where we take a risk-based approach and see, okay, what are the most sensitive contracts that we want to look to repaper. But that's probably for us a pragmatic position to take.
Okay. There's another question that we've got, and I'm just looking at the time. We've got about 5 minutes before we wrap up. Are there different processes you can adopt when transferring smaller amounts of personal data as opposed to large scale? Anybody want to answer that one?
And I'm not a lawyer, but I think they're subject to the same legislation, whether it's one record or 100.
Yeah, I mean, the only time that you rely on the other exemptions is where it's not a regular transfer, but where it just happens to be a one-off or I think the word is occasional. Then you don't need to be necessarily putting in place contractual clauses. But again, I think you'd still want to be doing due diligence, whether, as you say, Joe, it's 50 or it's 50 million. It still could be the worst transfer you ever do.
Yeah.
So I'm just having a scan. I think we've had loads and loads of questions. I'm also very, very grateful to Jürgen for saying that actually us in the UK are nice people. We wouldn't be seen as nice people. And I do thank a couple of attendees for reminding us that MailChimp was the part of a Bavarian court decision on whether they were transferring adequately or not. So thank you to everybody. I'm just before I hand back to Julia, just going to say to Joe, any final closing thoughts that you've got?
I'll just say I think it was a great discussion, and one of the prominent things that came out for me is making rational decisions and doing your due diligence and your risk assessment rather than knee-jerk in all directions. And I think that's perhaps the best way to proceed with pretty much all parts of privacy, including what we discussed today.
Okay, and Yasmeen, any closing remarks?
Yeah, I just wrote a comment, have a plan. I think it's, as Joe said, it's like any substantial legal change. As a privacy person, you've got to sort of always be thinking ahead in terms of that legal change and what it might mean for your business, and therefore sort of extrapolate that, okay, do I start engaging with stakeholders this month about it, or is it something I can delay for 3 months? Because you don't want to fatigue the business either. So I think it's like, have a plan, have a thought out approach about it. So if somebody talks to you, you know how you want to approach it, and make those sort of risk-based decisions around that as well.
Okay, and Julia, any comments for you?
Yeah, I mean, in addition to what Joe and Yasmeen have already said, it's like, make sure you've got the basics right, sure your cybersecurity arrangements are in place, that you've got a good idea of who you've got contracts with, that your ROPA is up to date. There's an awful lot of stuff you can do which isn't directly related to the SCCs, which will help you be ready when they are eventually approved.
Yeah, and I just got one before I do hand back to you, Julia. We had a question just while you were talking about where do we find the exceptions for where we can transfer without necessarily using contractual solutions. But I see that Philippa has very kindly given a link to the ICO guidance. But don't forget, it's not all about the standard contractual clauses, and it may well be that it's BCRs that's your solution, or in due course we'll have codes of conduct and certifications, and I'm sure we will find a solution to this in due course, because as several of us have said, data doesn't necessarily respect borders. It's always moving. We're not going to stop that. So with that from me, Robert, I'm going to hand back to you, Julia.
Great. Thank you, Robert. So first of all, can I thank the panelists, Robert for being a fabulous chair, as always, Yasmeen and Joe. I think we had a great discussion. Thank you, everyone, for joining us today. We will have the recording up on the DPN website tomorrow, I think by the afternoon. We've also got a lot of other materials around international transfers, as well as many other topics, including supplier contracts and all that kind of stuff. So for now, I'd just like to say thank you very much and good afternoon.
Thank you.
Bye.